1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်300 Union of Burma Appellant vs MAUNG Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Criminal Appeal before ဦးသက်ဖေ Judge Union of Burma Appellant vs MAUNG Respondent Public Property Protection Act Section 6(1) While committing theft of petrol belonging to the people wine industry, arrest of accused, legality or otherwise of the arrest, whether it can affect the question the accused is or is not guilty of the offense charged, whether the conviction is vitiated. Held, the trial court had held that the respondent was arrested while committing theft of petrol belonging to the people wine industry. His arrest under the circumstances cannot therefore be said either irregular or illegal. Even assuming that the arrest of the respondent is illegal, which is not the legality or otherwise of the arrest, cannot in any way affect the question whether the accused is or is not guilty of the offense with which he was charged, and the conviction of an accused will not be vitiated simply because the arrest is illegal. The State vs. Tudor 2 LBR 60. The State vs. Ravelu KC Kadu ILR 26 Madrid 124. The State vs. Madho Dobi ILR 31 Kalakata 557 refer to Taihan Government Advocate for the Appellant, Kokoji 3 for the Respondent, Uttape Judge. In Criminal Regular Trial numbered 155 of 1964 of the Second Additional Magistrate Chow, the respondent was convicted and sentenced to imprisonment till the rising of the court and a fine of Jet 150 or in default to undergo 6 months rigorous imprisonment under Section 6(1) of the Public Property Protection Act. On appeal to the Court of Session, Magui, the respondent was acquitted on the ground that the trial was illegal and void inasmuch as the arrest of the respondent was in contravention of Section 7 of the Public Property Protection Act. The Union government has now preferred the present appeal against the order of acquittal. The respondent was a driver in people wine industry, Chow, on 28 March 1964, Umamaukin, Assistant Security Officer, Chow, people wine industry, after receipt of information that the respondent was pilfering petrol from the motor vehicles belonging to the people's wine industry, schedule lorry numbered B8545 driven by the respondent, who stopped the vehicle in front of the house of one Ula Maung. The respondent then alighted from the lorry and started extracting petrol from the fuel tank of the vehicle. by means of a flexible pipe and some jerry cans supplied by one MAUNG Shui. At this juncture, Maung King, who had brought a camera with him, took some snapshots of the respondent, who was then handed over to Ba Xin, a corporal of the police force, Chao, together with some 12 gallons of petrol seized from him. La Maung and MAUNG Shui were also sentenced for trial with the respondent, but since they are not parties to this appeal, it would be unnecessary for me to refer them any further. In the trial court, the respondent pleaded that he was merely trying to clear the fuel system of the vehicle, which was then blocked with that, and that he was not stealing petrol. His plea was, however, rejected by the learned trial magistrate, who convicted him as noted above. On appeal against the conviction and sentence, the learned session judge, without going into the merits of the appeal, acquitted the respondent after arriving at the conclusion that the arrest of the respondent in contravention of Section 7 Public Property Protection Act vitiated the entire proceedings. Subsection 1, 2, and 2A of Section 7 of the Act, on which the learned session judge based his order of acquittal, read: 7.1. Any police officer not below the rank of a sub-inspector or any other officer of government empowered in this behalf by general or special order by the President of the Union may, with the prior approval of such authority as may be prescribed by the President of the Union, arrest without warrant any person whom he suspects of having committed or of committing any of the offences mentioned in subsection 1 of Section 6 in respect of any public property. 2. Any officer authorized in this behalf by general or special order by the President of the Union may arrest without warrant any person whom he suspects of having committed or of committing any prejudicial act. 2A. Any officer authorized in this behalf by general or special order by the President of the Union may, if he is satisfied with respect to any particular person that circumstances exist which render it necessary to arrest him with a view to preventing him from committing any offense mentioned in Section 6.1 or an offense of criminal breach of trust in respect of any public property or any prejudicial act, do so without warrant. Subsection 2, which deals with prejudicial acts, has no relevance whatsoever to the instant case. Subsection 1 and 2A relate to cases where persons are arrested for suspicion of having committed or of committing or for preventing him from committing any of the offense mentioned in Section 6.1. They have no application to cases where the culprits are caught red-handed in the act of committing any of the offenses mentioned in Section 6.1. Section 7 has been enacted where a person is required to be arrested and detained for a period extending to 6 months on being suspected of having committed or of committing any prejudicial act or any of the offenses mentioned in Section 6.1. Since Section 6.1 is a non-bailable and cognizable offense, a person who is found to have committed such an offense can be arrested by any police officer without a warrant under Section 54 Criminal Procedure Code. In fact, under Section 59 Criminal Procedure Code, even a private person can arrest a person who commits a non-bailable and cognizable offense in his view. In the instant case, the trial court had held that the respondent was arrested while committing a theft of petrol belonging to the people oil industry. His arrest under the circumstances cannot therefore be said either irregular or illegal. Even assuming that the arrest of the respondent is illegal, which it is not, the legality or otherwise of the arrest cannot in any way affect the question whether the accused is or is not guilty of the offense with which he was charged, and the conviction of an accused will not be vitiated simply because the arrest is illegal. In this connection, it has been held in the State vs. Tudor 1 that illegality in making an arrest does not necessarily invalidate a trial. The same view has been expressed in the State vs. Ravelu, KC Kadu 2. The relevant portion of it had no risk that the question whether the officer who effected the arrest was acting within or beyond his powers in making the arrest did not affect the question whether the accused was or was not guilty of the offense with which he was charged. See also the State vs. Madho Dobi 3. In the result, the appeal succeeds and the order of acquittal is hereby set aside, and I direct that the Learned Session Judge McGuire shall rehear the appeal of the respondent on merits